So should we start? Good afternoon. It's already afternoon. Everyone. My name is Gleb Bogush, and I'm associate professor in Moscow State University. And this is a really special honor and pleasure to me to be moderated for this workshop dedicated to the role of the International Criminal Court dealing with the post-conflict and maybe even pro-conflict justice in Ukraine. You know that we have the change of the program, the change of the timing, emerged from the plenary, and now the time pressure is emerged. So I really call all our participants and all our speakers to do the best to fit into 10 minutes. In order we have the chance to discuss and to ask questions. So please be as brief as you can. The issue of International Criminal Court is one of the crucial in discussing the conflict in Ukraine, the justice option, the justice avenues in the post-conflict Ukraine, and I think everyone knows that the International Criminal Court is the only international criminal court that has jurisdiction over the territory of Ukraine, owing to the declaration, ad hoc declaration, so-called Article 12 declaration of Ukraine, and now the prosecutor still holding the preliminary examination into the situation. The investigation is still not opened, but activities of the court already caused some consequences, especially regarding to the Russian decision to withdraw its signature from the statute. It was one of the reasons, at least put officially to officially disengage from the cooperation with the court from the Russian Federation, and the International Criminal Court role was already discussed during our plenary session from various perspectives, and of course this engagement of the International Criminal Court raises a lot of issues, and we have various issues during for discussion. And let me introduce the first speaker. It's Dr. Irina Marchuk. Irina is associate professor at the University of Copenhagen, Denmark, and she's a frequent author, and she published the monograph on international criminal law, the concept of crime, and everyone who following the most popular international law blogs, I think, very familiar with her publications. In particular, dealing with the international justice role in dealing with Ukraine. So the floor is yours, and we are really looking forward to your presentation.
Yeah, thank you very much. I'm also having a PowerPoint presentation. I would like to thank organizers for organizing this fantastic conference. On the one hand, I'm very happy to be to Ukraine. I haven't been to Kyiv for the last 11 years. And I'm very nostalgic and almost cried when I came to Kyiv and saw Maidan Square. But then I'm actually very sad, because since I developed my interest in international criminal law, in my research, I focused on other conflicts, and that was the conflict in the former Yugoslavia, conflict in Sierra Leone, and I could never imagine that my expertise in international criminal justice would be relevant for my homeland. And as Gleb said, I've been publishing quite a lot about Ukraine's actions before different international courts. I have only 15 minutes, and I will be quite boring and legalistic. I will try to speak slowly, as I imagine that some of you are not lawyers, so I will try to simplify my arguments. I have 85 pages of work that I have already published about Ukraine and the International Criminal Court, and it will be very difficult for me to summarize my arguments in 10-15 minutes. that I have, but I try to do my best. Normally, when I give a talk about Ukraine and the International Criminal Court in Scandinavia, I provide a few slides about the background. But I guess everybody knows what has happened in Ukraine since 2013, so there is no need to repeat the information that everybody knows in the room. So I will go straight to the International Criminal Court. Yes, and these are a few basic facts, and I apologize to those who are experts in international criminal justice, because this is very basic, but I thought it's important for those who are non-lawyers in the room. So the International Criminal Court is the first permanent treaty-based international criminal court that was established to help end impunity for the perpetrators of international crimes. The International Criminal Court is governed by the Rome Statute. It has the jurisdiction over genocide, war crimes, and crimes against humanity, as well as potentially the crime of aggression, subject to decision about the exercise of the jurisdiction over the crime this year. The International Criminal Court operates on the basis of the principle of complementarity. What it means? So the International Criminal Court is complementary to national proceedings. There is great misunderstanding that the ICC prosecutor is interested to have as many cases as possible in the court. But in fact, the former prosecutor, Luis Moreno Campos, said that a perfect day for me would be when I come to my office and I don't have a single case. This means that the principle of complementarity is working and that national authorities that ratify the Rome Statute, they have the ability and willingness to prosecute these crimes. So the mandate of the ICC is not to prosecute as many crimes as possible in as many conflicts as possible, but in fact also to ensure national capacity building. That's really important. So let's move to the relationship between Ukraine and the International Criminal Court. Ukraine signed the Rome Statute in 2000, but did not ratify the Rome Statute. Why? Because in 2001, there was the decision of the Constitutional Court of Ukraine that declared the Rome Statute to be in conflict with the Constitution of Ukraine. So if one were to open the Constitution of Ukraine, it says that the administration of justice is the exclusive competence of national courts. So therefore, the Constitutional Court of Ukraine interpreted this provision as being contrary to the ICC's principle of complementarity. Despite the fact that there were calls for Ukraine to ratify the Rome Statute, amend its constitution to accommodate for the jurisdiction of the ICC, this has not been done. So in 2008, in 2014, in 2015, there were law drafts in the Ukrainian parliament with very little public information available on the website of the parliament what has happened to all these law drafts. But Ukraine has not ratified the Rome Statute, which I consider to be is a big failure. On the one hand, Ukraine wants the crimes in Ukraine to be prosecuted in Ukraine. On the other hand, the Ukrainian parliament cannot do a very simple step, which is basically to write in one sentence in the Constitution of Ukraine. So a very peculiar situation that we have right now, that the ruling of the Constitutional Court of Ukraine is still in force. So technically, the Rome Statute is contrary to the Constitution of Ukraine. Regardless of this, the Ukrainian government goes to the ICC, lodges the declaration accepting the jurisdiction of the court. The ICC prosecutor has not dealt with this constitutional law issue, but it's actually quite interesting for me. If the case moves forward, will the ICC judges look at the fact that we still have the valid ruling of the Constitutional Court of Ukraine that says that the Rome Statute principle of complementarity is contrary to the Constitution of Ukraine? So moving to the declarations. Following the Maidan crimes, on the 25th February 2014, Ukrainian parliament accepted the ad hoc jurisdiction of the ICC. I don't know why, but it took our parliament 3 months before they actually went to The Hague and lodged the declaration with the ICC registrar. I would try to pinpoint some of the major problems that we have with respect to the first declaration. So the first question that I have, oh, sorry, I'm just changing my slides here. I'm thinking that they've been automatically changed. Yes. So the very first question that I have already addressed, and maybe we can discuss it further during our discussion time, does the declaration override the earlier ruling of the Constitutional Court of Ukraine? And here what's important is the relationship between the constitutional law and international law. Another question, and there was a lot written about it, whether the declaration was duly signed. According to the Constitution, the person who should be signing this declaration is the President of Ukraine. Our former president, beloved former president Yanukovych, fled the country. So technically there was no president. The chairperson of the Parliament of Ukraine assumed his function as ex officio head of state, and he signed the declaration. So when I was reading the blogs, various blogs, people were saying, well, okay, Ukraine submitted the declaration to the ICC, but the declaration is not valid anyway, because the chairperson of the parliament, who was acting as ex officio head of state, was not entitled to sign the declaration in accordance with the Constitution of Ukraine. So far, nothing has been said about it by the ICC prosecutor, so it's interesting if the pre-trial chamber, if the case goes further, will actually look into the issue, who was supposed to sign the declaration on behalf of the Ukrainian government. We talk a lot about victor's justice, and Ukraine used its declarations to highlight its grievances of what has happened during the Maidan, which is quite understandable. And the Ukrainian parliament names the suspects, and the suspects, as you know, include the president of Ukraine, the former general prosecutor of Ukraine, very high-ranking ministers. The Ukrainian parliament was not entitled to do that. It's the ICC prosecutor that decides who will be suspected of these crimes. The ICC prosecutor will decide on whether to levy the charges against the president or the senior officials. But the ICC prosecutor is not bound by the names that appear in Ukraine's declarations. And I think that's important to remember as well. The first declaration was only limited to Maidan crimes, so it was only from November to February 2014. So what has happened to the first declaration? The prosecutor took 1.5 years, which I think was quite fast. When we look at the situation in Georgia, it took the prosecutor long 7 years to say something sensible about the situation, and actually concluded that there is limited information at this stage to support the conclusion that the alleged attack carried out in the context of the Maidan protest was either widespread or systematic. Translating it, for those of you who are not lawyers, basically what the prosecutor says, yes, the crimes that took place during the Maidan, as awful as they are, they do not constitute crimes against humanity. I wrote an article about it, and I will be very brief. It was published 1 month ago with the Boston University International Law Journal, and the title is "No Crimes Against Humanity During the Maidan Protest in Ukraine?" ? Or the ICC prosecutors' flawed interpretation of crimes against humanity ? So what I argue that Maidan crimes satisfy the definition of crimes against humanity. And here there is, we'll go to further slide, and here you can see some of my major arguments. Unfortunately, I cannot develop my argument as I do not have time, but I argue that when you talk about crimes against humanity, we don't have to prove that the crimes are widespread and systematic. It's sufficient to prove that the crimes are either widespread or systematic. And I argue that Maidan crimes satisfy the systematic requirement. And here are some of the arguments that I advanced. These are the criteria that points towards the fact that the attack was systematic. So I argue that we have the state policy, and the ICC prosecutor actually found that the state policy existed to target the peaceful protesters, which is one of the important indicators of the systematic requirement. I also say that the Maidan violence was organized and followed the regular pattern of behavior by the law enforcement units and titushki. Also, I say that there was repeated and continuous commission of crimes, which is well documented as well. There is a report that was issued by the Council of Europe. there is an implication of high-level officials, which is also an important indicator that the attack was systematic. And there is failure to punish the crimes. So what I say, that the prosecutor, first of all, did not correctly apply the definition of crimes against humanity to qualify the events in Ukraine. And I say as well that the prosecutor applied an unreasonably high evidentiary threshold at this stage of proceedings. And it's very unfortunate that the ICC prosecutor stripped off the ICC judges of the opportunity to decide whether Maidan crimes constitute crimes against humanity. Ukraine said that they will be submitting additional evidence about Maidan crimes. I don't know what has happened, so it might be that we'll still hear something about Maidan crimes, but as it looks right now, the ICC prosecutor will not be investigating Maidan crimes. Going to the second declaration, and I will be very brief as well. We have the same problem with the signature. So we already had President Poroshenko who was elected, but he did not sign the declaration. And I don't know why he did not do it. So it was still the chairperson of the parliament who signed the declaration on behalf of Ukraine. Although we had already the president who was sworn in his office. Then we have, of course, this very difficult dichotomy between the international and non-international armed conflict. So what the ICC prosecutor already said. The ICC prosecutor said that we have an international armed conflict on the territory of Crimea, and with respect to the conflict in eastern Ukraine, the ICC prosecutor still doesn't know whether we have a single international armed conflict. That is provided that the ICC prosecutor will find enough evidence on Russia's effective control over the rebel groups in eastern Ukraine, or actually we have two types of conflict. Do we have this so-called hybrid warfare, so a non-international armed conflict running in parallel to international armed conflict? So here the prosecutor will have to deal with some very challenging questions, because if the prosecutor establishes Russia's effective control, that of course will open Pandora box, and here the ICC prosecutor will also have to choose suspects, and that would be huge, of course, if we have Russian citizens who are suspected of crimes committed in Ukraine and arrest warrants are becoming public. Then there were a lot of talks about the MH17, what court could possibly prosecute the crimes. And what's interesting that when Ukraine submitted the second declaration, it said that the ICC jurisdiction should only apply in relation to victims who are Ukrainian nationals. So by introducing this limitation to the declaration, the ICC prosecutor said that basically all other nationals, let's say, who lost their lives on the territory of Ukraine, that they will not be covered by the second declaration. The ICC prosecutor is not bound by it. So technically also the ICC prosecutor will be able to look at the MH17 events. I'm just concluding because I know that we are running out of time. So why ICC? Because national courts are not a viable option. Although there were attempts to prosecute Maidan crimes, we have very few cases that have been finalized. Well, there is a registry on the crimes that were committed during the Maidan protests, but we have very, very few cases of low-ranked perpetrators that made it to the courts. Capacity building. Ukraine does not have expertise dealing with international crimes. As well, when we look at the criminal code of Ukraine, it doesn't provide for a comprehensive list of international crimes. We have very few crimes that could be relevant. And therefore, all the crimes are being prosecuted on the basis of general criminal law provisions on murder, torture, infliction of bodily harm. It's important that Ukraine cooperates with the ICC, and I always read in the media that Ukrainian government is cooperating with the ICC. I'm wondering what kind of evidence they are submitting, because it's not quite clear when you read the media whether Ukraine is doing a proper job in cooperating with the ICC, but that should be a priority for the Ukrainian government. Then also the ratification of the Rome Statute, as I said, should be a priority for Ukraine. I think it's shameful to be sitting here and talking about the fact that Ukraine still needs to ratify the Rome Statute, something that should have been done a long time ago. As well, Ukraine is pursuing parallel proceedings before other international courts. So we have interstate applications against Russia in the European Court of Human Rights. We have the ICJ case of Ukraine versus Russia. We have the ICC proceedings. So Ukraine emulates Georgian litigation tactics when they also brought the cases before different international courts. So that's quite interesting for me what's going to happen, and in fact how these courts will interact. Because when we have the first findings of the court, then it's quite natural that the other courts, with the pending judgments, would look at the findings of other tribunal, and there could be some cross-fertilization. Cross-fertilization of judicial reasoning from one court to another. So I think here I stop, and I hope that we'll discuss more during the discussion, and I give floor to another speaker.
Thank you very much, Rina, for this comprehensive coverage of the legal problems arising from the ICC jurisdiction of Ukrainian conflict. Now we move to the non-classical legal stuff, and actually Dmitro Kovalyu, Dr. Kovalyu is associate professor from Odessa, the Law Academy, and also he represents the Sociology Graduate School for Social Research in Polish Academy of Sciences. And Dmitro's presentation dealing with the looks at the problem of international courts from the through the different lenses. It's the issue of collective memory in social systems, and I suggest, Dmitro, you to start with the explanations of your title, which is the 11th dimension of the international criminal courts. The floor is yours. We are looking forward.
Thank you, Gleb. Irina, may I ask for a clicker?
Yes.
First of all, I would like to thank you, organizers, for inviting me to have this possibility to share my ideas during this presentation. And I would like to start with a short disclaimer. My presentation will not deal with, at least deeply deal with Ukrainian crisis and Ukrainian issues. It's rather a theoretical attempt to comprehend the interplay between international criminal courts and collective memory. And of course, I have to start with the explanation of the title of this wording, 11th dimension. Here you can see the 6D model of six unobservable dimensions from quantum physics. So 10 dimensions, the dimensions from quantum physics, and the 11th one is a memory dimension. The only thing I wanted to underline by this title is that international criminal courts influence the reality of the societies in many different ways, and memory is one and important dimension, important way international criminal courts interplay with the society. Here you can see the picture of the founder of the notion of collective memory. I think that all of you, or maybe part of you, are acquainted with the idea of collective memory. So here I would like only to present the core ideas on which my understanding of collective memory is based. And these ideas actually derive from the two books written by Maurice Albach in the very beginning of 20th century. So I perceive collective memory as a memory of individuals, but not of some communities or social groups. According to Albach, and I accept this idea, memory is acquired in society, and it is formed by creating of frames and conventions of frames of these memories. This means that when we try to remember some fact, we localize it. We localize our memories. We remember also the context of this event or of some particular experience. We determine the time and place where this event or some communication happened. This move us to the second pillar point of Albach's theory, is the idea that remembering is impossible without thinking about it. And this is the point where my perception overlaps somehow with the Marko Milanovic idea that we think about the events together with emotionally perceive them. So we remember events and simultaneously we think about that, about those events. And thinking about events means to correlate our thoughts, our remembering, our recollection with the reasoning coming from our social environment. After Albach's, actually, a lot of other important issues were studied in this discourse of collective memory. I will just speed up with this slide just to make some. I'm going to make some bullet points concerning this after Albachian scholarship. So a lot of authors wrote about collective memory, and they represented different disciplines: psychology, socio-psychology, anthropology, legal science, many other fields of expertise. Now, collective memory is much more perceived as a memory of collectives, of societies, but not as a memory of individuals. And I actually apply this idea, but in quite different way, in the way that is present on this second bullet point, externalization of collective memory. So now we rely to some external sources when remembering, not to our personal autobiographical experience. Collective memory is strongly dependent on mnemonic practices and institutional support, and actually institutional support is why this poster of George Orwell 1984 is present on this slide. Then collective memory now is perceived as consist of these three particles: semantic collective memory, episodic, and procedural. Maybe later on the lobbies of the conference we can discuss this division. I will not stop on this right now. Now I'm moving to the International Criminal Court's interplay with collective memory, and the first thing I would like to stress your attention is that is the theoretical assumptions. What make me think that international criminal courts are capable in principle to influence collective memory? First, its history is often told with the references to criminal proceedings. Starting from ancient authors, for instance, this one, Tacitus, history is told by referring to some proceedings, to their findings. Here you can see the very short list of cases that are usually used to tell the history: Dreyfus, Edelji, Kononov versus Latvia, the recent civil case Irving versus Penning Books, and many others. Antonio Cassese and Moshe Hirsch made 4 points of distinguished 4 parameters that make international criminal courts capable to influence collective memory. They are power, legitimacy, public attention, and formal procedures parameter. Since I'm trying to look at the problem of interplay between international criminal courts and collective memory from system theory perspective, the very important or the core idea of this theory is a division on system and environment. So I propose to construct, to build the two-level model. On the first level, the international criminal courts should be perceived as an environment, and society should be perceived as a system. On the second level, society will be an environment, and collective memory, individual collective memory, will be a system. This model allows us to distance from the very common understanding of interplay between international criminal courts and society. This model allows to distance from the idea that some total dependency exists between environment and system, between international criminal courts and society and collective memory. This division on memory on system and environment may be retold in another terms. We can say that international criminal courts are memory producers, that individuals are memory consumers, and then society is a memory retailer, the institution that sells memories for individuals. International criminal courts produce senses, produce impulses that reach the system. But since international criminal courts are the environment but not the part of the system, their activity has not direct influence, causational influence on the societies and on the collective memory. That is why what I'm saying is that international criminal courts raise the complexity of the system. This means that the probability increases, probability of some changes of the discussion of international criminal court finding increases. Messages from the environment, from the international criminal courts, are too complex to be perceived by the societies in their pure primordial form. That is why they are being generalized. This means simplified. No society think about genocide committed on their territory, on territory they are living, in terms of all the elements of that crime. The simple message that society can perceive is that genocide was committed, or the guilty persons were found, or someone was charged with these offenses, but not in the sense of this very comprehensive and complex legal construct, genocide. The influence of society and environment is a two-way influence. So the senses infiltrate from the environment, from the international criminal courts to the system, and from the system, from the society to the international criminal courts. I insist that international criminal courts influence the society through different channels, and I see at least 3 channels through which international criminal courts can influence society. They are direct one, implementational one, and symbolic one. These channels are operated by the channel operators, and what international criminal courts do for these channel operators, they create some frames, justice frames, law frames, through which the events are covered by the operators. Former Yugoslavia is a good example in this regard, since till the creation of the ICTY, media coverage of the events on the territory of former Yugoslavia was not, media didn't use such terms as international crimes or persons that are guilty for the mass atrocities or something like that. So the simple initiating of the tribunal, the founding of this tribunal influenced the way society started to perceive the international criminal. So the first channel, it's a direct one. International criminal courts are the sole operator of this channel. It's the most narrow one. Only some groups of some society groups can benefit from this channel. You can see here Dominic on one picture, and the reason why he's here is that in that case, International Criminal Court launched a free SMS public information platform that aims to widen the channel of influence, to reach more the bigger parts of the society through these channels by delivering the information from the horse mouth to the members of the society. The implementation of the channel is represented by the national court proceedings, and here we can remember, of course, Ayman case, national courts in Kosovo, Bosnia and Herzegovina, Rwanda, also Gacaca trials in Rwanda, and another way this channel may be understood is a memory laws, so-called memory laws. Usually the 4 types of these laws are distinguished. Here are they. Then symbolic channel. This channel is represented by museums. Here you can see the picture taken by myself from Srebrenica Potocari Memorial Center. in Srebrenica. Actually, this channel is also represented by the movies, Judgment in Nuremberg, The Storm are the most frequently referred in this regard. Books, monuments, arts, some other forms such as models of international criminal courts also represent these channel. The signal from the International Criminal Court deviate from their meaning, the meaning that was programmed by the International Court. Not only generalization or simplification of message cause this deviation of signal, deviation of meaning of senses. The most popular channels, the second and third channel, the channels that reach the wider group of wider part of society, are most vulnerable in terms of deviation and both because operators for their needs or their aims deviate somehow information, but also because societies, individuals, and international criminal courts' peculiarities, parameters provoke such a deviation. The deviation of messages may be caused by some intentional actions or unintentional. Among intentional deviations, so the actions that lead to intentional deviation, we can name the Ayman case. Many scholars stress that, insist that Ben-Gurion, the first president of Israel, for purpose made that trial very political to retell the story of Holocaust. And that is the example of the intentional change of paradigm, intentional change of sense of message coming from the International Criminal Court. And unintentional change may be exemplified, illustrated by the Kosovo courts. You know that the program of international courts and prosecutors exists in Kosovo, and the interesting fact is that Kosovo courts made finding that genocide occurred on the territory of Kosovo, but the courts, the appeal courts, where these international judges were present, stressed that no genocide occurred because of ICTI decision on this matter. So, so that is why Kosovo courts really wanted to find genocide in the Kosovo situation, because they emotionally understand the reality. They emotionally perceive the reality. I'm ending. So I thought that also from the international criminal courts, messages, and societies' peculiarities, this deviation depends. Here are the very short list of some peculiarities that may be important for this discourse: legitimacy and legality, place of seat, trust toward the court. When it comes to the messages coming from the International Criminal Court, they have this limited institutional logic through which judicial proceedings filter events on the ground. Then binary logic of international criminal law that misses gray zones among perpetrators and victims. When it comes to the society, the individualistic and collectivistic societies exist. What is interesting is that only Germany was the case when International Criminal Court dealt with individualistic society, and that experience was the most good, I think, in terms of changing collective memory. All other situations happened, I mean, all other international criminal courts dealt with the situations in the collectivistic society. There are some other important features, and yeah, I'm turning to the conclusions. What I wanted to stress by this presentation, by this try to shape up the traditional discourse concerning the interplay between memory and international criminal codes, is that no causational interrelation exists between ICCs and collective memory. Then that international criminal codes activity raises the probability of changing, but not necessarily change the collective memory. Not all factors are in the hands of international criminal codes, so not only international criminal codes are responsible for the changing of narratives in the society, for changing of the of the collective memory. And very important is that the bad perception of international criminal courts in the society does not mean that these courts are not influencing into the collective memory. So thank you. It was my pleasure to. Yeah.
Thank you, Dmitro, for your really interesting presentation. Thank you very much, and I really like this idea of signals or messages that are sent from international courts, and I wonder what kind of signal is now International Criminal Court is sending on the ground. The next speaker is Gainea Nurijanyan. She is a PhD candidate at the University College London, and she will address the issue of the ICC competence to review completed domestic proceedings. It deals with the complementarity principle that was mentioned by Irina before. So the floor is yours, please.
Thank you, Clem. Well, I'm going to continue the legalistic stream of this panel, and I'm sure the law geeks will like it, but I guess I have to apologize for the rest of the audience for taking you through these dark woods of the Rome Statute. So I will be talking about the competence of the court to step in when there has been already a completed domestic trial, and I'll perhaps again start with the tried statement about ICC's competence being of complementary nature and being based on the idea that it is for the jurisdiction, for the national jurisdictions to take charge of, first and foremost, to prosecute and try international crimes. However, this principle of complementarity and the principle of primacy of domestic jurisdiction is not unlimited. There are limits that are found in the admissibility framework of the ICC statute, and I will look particularly at one aspect, a scenario in which there has already been a trial, so the person has been already tried for specific conduct, and this scenario is addressed by Article 17, paragraph 1c of the Rome Statute, which says that the case is inadmissible if the person has already been tried for conduct that is sought to be tried before the ICC, and a trial by the court is not permitted by Article 20, paragraph 3. So we go to Article 20, paragraph 3 to see what are actually the contours of this competence of the ICC, what are the limits of the ICC's competence to step in such scenarios. And Article 23 is one of the provisions on ne bis in idem. So in other words, it's a rule that protects against double jeopardy. And it says that no person who has been tried by another court shall be tried by the court with respect to the same conduct. And there are exceptions to this rule. And the exceptions are about the character of the domestic proceedings. So if the domestic proceedings or proceedings before this another court were a sham trial, were not genuine, the court will have competence to step in. And I will again focus on several aspects here which I think determine the limits of this competence of the court, and they are about the limits of the they are about actually specific terms that define these limits. And the first one is about what proceedings before which courts actually trigger the application of inadmissibility rules and trigger application of ne bis in idem rule. And I will focus in particular on the determination, the interpretation of this term another court, and I will briefly address other aspects which are about the moment when the ne bis in idem rule is triggered and the scope of the domestic trial that is protected by ne bis in idem rule, and then I will mention briefly the exceptions. So it is the trial before another court for the same conduct that prevents the court from trying the person again. And what is this another court? So this can be a domestic court in party or non-party state. It can also be another international criminal court or tribunal. But the question I would like to focus on here is, does this cover non-state courts? And in this specific setting, I'm using the term non-state courts as courts that are established in an unrecognized, self-proclaimed state or entity, or the courts or criminal trials that are conducted by non-state organized armed groups. And the court, the ICC, has actually addressed this issue in passing very briefly in the situation of Georgia, where it actually agreed with the prosecutor's argument that proceedings before South Ossetian's court should not be taken into consideration when the court decides whether there is the admissibility criteria are met or not. It doesn't, because it is not an unrecognized state, the proceedings before such courts are not taken into account. Some scholars have advanced actually a different and opposite argument, saying, well, look at the term another court. It doesn't say another international court, another domestic, municipal court. It doesn't speak of a state that has a jurisdiction. So actually the textual interpretation allows us to take into consideration proceedings before the courts that are not necessarily part of the state system. In my opinion, if we look at contextual elements and object and purpose, if we look at other rules of international law, we may actually reach a different conclusion. Well, first of all, the Rome Statute has established a system that operates on the one hand between the sovereign state and on the other hand between the ICC. The preamble speaks about the national jurisdictions, duty to prosecute international crimes. The Rome Statute is complementary to national jurisdiction, so we have sovereign state and the ICC in this relationship. The admissibility framework of the court is also based on the relationship between sovereign state and an ICC. It talks about a state which has jurisdiction that is prosecuting or trying the person. It talks also about the right of a state or an individual and non other entity to challenge the admissibility of a case before the court. Another point to be made here is when we look at other, for example, rules of international law that where the domestic courts are taken into consideration, and if we look at the customary international law rule on exhaustion of domestic remedies, it is the remedies that are part of the municipal or legal system that is based on municipal law that are to be taken into consideration. And if we are talking about the courts that belong to unrecognized entities or courts that are established by an armed group, they will unlikely be a part of this constitutional framework of judicial remedies available in a state. What is more, they may not actually constitute a court in the sense of a tribunal established by law that is capable of trying the person with providing all the necessary indispensable judicial guarantees. And the final point that I would like to make here is that such courts, the proceedings or the trial before such courts may actually amount to a war crime, or an entity that established such courts can come actually into being in breach of a rule of international law, so that it would be at odds with the principle that legal rights cannot stem from unlawful situation, to consider that we have to take into consideration proceedings before such courts for the purposes of admissibility. And I will just briefly address some other points, which is the term has been tried. What does it mean the person has been tried? Well, it has to be a judicial trial, so proceedings before the Truth and Reconciliation Commission's amnesties that follow such proceedings will not constitute a trial for the purposes of this rule. It doesn't mean that the court cannot take that into consideration when it decides whether there needs to be a prosecution or not by the ICC. It's just that this rule does not, it only starts to apply when we have a trial. Same conduct. Again, the ICC allows, because of the principle of complementarity, it allows the domestic courts to decide how they characterize legally the conduct. In order for the case to be inadmissible before the court, it does not necessarily need there does not necessarily need to be a prosecution at the domestic level for international crimes. It's enough to prosecute conduct as a domestic crime. And this is a situation which is different from the statutes of ad hoc tribunals, where there is an exception, ordinary crime exception. However, the decision of how to prosecute a conduct that is alleged to be an international crime may be relevant when we look at the exceptions to the principle. So there is an exception to nebis in idem which talks about, which gives the court competence to step in when there is a sham trial, where there is an intention by this domestic trial to shield the person from the responsibility. And here we can look, actually, what can be one of the indicators of this intention to shield from criminal responsibility. It can be how the conduct is characterized domestically. So one more time, and in of itself, the trial for domestic crime does not give a competence to the court for the ICC to step in. But for example, if we have an act that we have victims, for example, that have received injuries, or we have murdered victims, and if, for example, in such situation, a member of armed forces is prosecuted or tried at the domestic level for insubordination or failure to observe orders, then the question of intention to shield the person from criminal responsibility may arise. And I think I will stop here. Thank you.
Thank you. Thank you very much for guiding us through this dark woods of the Rome Statute. And now we have the presentation, which is also a bit like Dmitrov's one, is a bit so legal, but actually addresses the issue that we'll also discuss during the plenary session. The speaker is Valentina Polunina. She's a PhD candidate in University of Munich, Germany, and she will talk on acceptance of international criminal justice in Ukraine. The floor is yours.
Thank you, Tim. I'm actually based in Munich now, but I'm teaching there. I'm a PhD student. It's okay. So today I will be talking about a short survey I conducted
Microphone.
Oh, sorry, yeah. I conducted a year ago in Ukraine. The previous speakers have already given some basic information, so I will skip this part and we'll go directly to the summary of the findings of this survey. Can you please switch on the presentation? Yeah. The survey is on the acceptance of international criminal justice in Ukraine by different stakeholders. It was conducted for the International Nuremberg Principles Academy. This organization is based in Nuremberg, Germany, on the premises of the Nuremberg Tribunal. And they also developed the methodology for this study with us together. And it's a part of a bigger project that deals with acceptance of ICJ in Central Eastern Europe, African countries, and Latin American countries. You can find the whole, it's already available online, the first link to the whole project, and the second one just to the Ukrainian case. The goal of this study was to understand how different actors in Ukraine relate to current situation and see international criminal justice, and also to look at if they accept or do not accept ICJ, if they accept what they accept and what they do not accept, and of course which factors influence their acceptance or non-acceptance. So acceptance in this case is defined as an agreement either expressly or by conduct to the principles of international criminal justice in one or more of its forms, laws, institutions, or processes. Just a couple of words about the methodology. This study draws on 70 oral and written semi-structured interviews that were conducted in Ukraine a year ago with different stakeholders, victims, local politicians, chief and special prosecutors, state security officers, legal experts, practicing lawyers, human rights activists, and others. And these interviews were divided into 5 separate categories according to the methodology of the organization: government, civil society, communities, and parties. The study has some limitations because it does not answer questions about the acceptance of ICJ by the Ukrainian society in general, but of course we can make some arguments about it too on the basis of the interviews with stakeholders. In general, on the basis of this study, it can be observed that various Ukrainian actors generally accept ICJ. When asked about attitudes towards ICJ in the Ukrainian societies, the majority of the interviews pointed to the wide acceptance by the public and requests for intervention of an international judicial body due to low trust in the national authorities in Ukraine. What is unusual about this public acceptance is that it is dynamic, and of course it exists in the situation of an ongoing conflict, and it's changing over time. And the respondents also stressed that acceptance in the Ukrainian society started diminishing due to the overall disappointment in the Western response to the war in Ukraine, concerns that the ICC could harm the Ukrainian military, little knowledge of the international criminal justice mechanisms, combined with too high expectations of international institutions. For instance, like it was in the case of the OSCE, when the hopes were very high, and now we have the situation when the OSCE is not that well regarded in the Ukrainian society. There is also concern that if the ICC waits for too long to open a case like it was in the Georgian situation, there will be little public support left in Ukraine. So let's talk about specific actors. First of all, the government. We've been discussing already their attitude towards the cooperation with the ICC and the ratification of the Rome Statute. It can be said that despite some steps towards acceptance, the lack of political will and understanding of the ICC's work and attempts to balance different interests of different stakeholders within Ukraine has created a situation in which the ICC's mechanisms are used selectively and are used as a political tool in Ukraine. This strategic selective approach is preferred not only by the government, but also by different opposition parties and movements, both left and right wing. The Ukrainian government cooperates with a reputable institution, in this case the ICC, in order to strengthen its version of the happenings in Ukraine in the ongoing propaganda war with Russia. And considering the EU-Ukraine agreement, the acceptance of the ICC could also contribute to good relations with the EU. And maybe it's not that valid anymore, but back then, a year ago, it was also contributing to the legitimization of the post-Maidan government. These are the reasons why the government cooperates. At the same time, the Ukrainian government is concerned that it will be vulnerable to Russian diplomatic attacks after the ratification of the Rome Statute, like it was in the Georgian case. And one of the most plausible explanations of this opportunistic approach is its fear that the ICC will open investigations against the Ukrainian military, and this would cause serious damage to Ukraine's image abroad and negatively affect the country's international support and also damage the peace process. The resistance of full acceptance with the ICC by the government could also be a result of a poor understanding of the court's mechanisms, as I said, and an inability of the officials to distinguish between conventional and international crimes. Differences between institutional and individual acceptance within the government can be observed. Cooperation with international legal bodies and the ratification of the Rome Statute was supported by the majority of the interviews from the category government, but mostly by mid-ranking and low-ranking officials. At the same time, a certain correlation was observed. The higher the status of a state official, the lower the level of acceptance of the ICC. Let's go to the civil society and legal experts. Civil society and experts generally have a high level of ICJ acceptance. They criticize the lack of understanding of ICJ mechanisms and insufficient political will to investigate and prosecute international crimes committed in Ukraine. They also criticize corruption. and unprofessionalism of national law enforcement agencies. At the same time, experts point to the fact that it is almost impossible to conduct investigations and bring to justice perpetrators on the territory that is not under Ukrainian control. So they recognize that the hands are bind, the hands of Ukrainian law and of Ukrainian bodies. It is a common belief also among the civil society that a hybrid ad hoc tribunal with mixed national and international staff would be an acceptable alternative to the ICC because it's not that time-consuming, and Ukrainian nationals will also be participating and learning from international experts. They also hope that this hybrid ad hoc tribunal will be able to prosecute the crimes of aggression and the crimes of corruption that currently cannot be dealt with by the ICC. Let's go to the victims and their perspective. Two different positions can be observed with regard to the acceptance among victims. For those who have become direct, let's say, direct victims of violence, not structural violence, but physical violence, mainly those who survived captivity by the separatist forces. I didn't talk with those who were victims of the Ukrainian forces. Unfortunately, I didn't have access to them. For them, it is immensely important that justice will be restored. They really mentioned it several times, justice. This word was very important. Communities under control of the separatist forces may be distrustful and resentful towards an international trial, to the lack of information, and also to the consummation of false information. And for those directly affected by violence, one of the most emotional issues was the question of amnesties. The majority of victims, but also many experts, human rights activists, and governmental officials are against blanket amnesties featured in the Minsk Agreement, as they argue that peace in Ukraine is impossible without at least some degree of justice. And it was, for instance, very important for victims that the justice is served. Parties. Most opposition parties and even some right-wing movements that I interviewed support an idea of some kind of investigation and a trial of what happened in Ukraine during the last 3 years. At the same time, their acceptance is also, like in the case with the government, is rather strategic, as they see justice generally directed at only the rivalry camp and not at themselves. The majority of the interviewed partners agreed that if the prosecutions will be one-sided and only the Ukrainian side will be tried in The Hague, for example, because it will not be possible to extradite alleged perpetrators from the Russian territory, those prosecutions will be negatively perceived in Ukraine. Because members of the Ukrainian military forces are generally seen as heroes and defenders of the homeland. At the same time, some experts pointed out the fact that there have already been some prosecutions and some investigations, and there hasn't been a big reaction in the society so far to these prosecutions. To the factors, the last point, different factors influence the acceptance of ICC and ICJ, such as the popular demand for accountability and the involvement of the ICC in the Ukrainian situation, in the situation where there is little trust in national law enforcement bodies, as well as the pressure of human rights activists. It's a very valid factor. They are very vocal and they are very active. Also legal experts, and of course the pressure of international partners such as the EU. So I will stop here. Thank you for your attention.
Thank you very much for this, for sharing this interesting research, and I hope that it would be also available for the prosecutor of the ICC, and I really appreciate that you mentioned the timing factor. It's very important for the domestic audience, for actually the target audience of the international criminal justice. Now we have time I'm not sure that we have much time for questions and answers. And I would offer this seat to Irina, and I invite also Dmitro to join the panel with your own chair. Yeah. I think it would be the best solution. And please, the floor is open. So, please.
Thank you for your presentations. My questions are very Ukraine-oriented, and they are aimed at Irina and Gaine. Irina, could you address the recent constitutional changes when the Parliament of Ukraine said that they will be able to recognize the jurisdiction of the ICC in 3 years? And don't you think that this formulation to recognize the jurisdiction and not to ratify the Rome Statute might be used as a carve-out to the jurisdiction of the ICC, say if the ICC decides to investigate Ukrainian military? And my question to the Guyana is that, again, I'm not sure how deep your research goes into the Ukrainian context, but could you comment whether the amendments to the Ukrainian legislation on trials in absentia, on absent trials, which are promoted a lot by the current Prosecutor General Office, how will they impact the proceedings of Ukraine in the ICC if the proceedings are open? Thank you.
Thank you. Let us first collect questions. For probably 1, 2 on this note. Okay.
Okay, I'm not sure that I understood it correctly. So your question with respect to the ICC was what would be the reaction of Ukraine, whether the cases will be initiated against Ukraine?
How do you assess the postponement of the recognition of the jurisdiction of the ICC as enshrined in the amendments to the Constitution last summer? How do you assess the impact on the potential jurisdiction of the ICC over the Ukrainian case, if you looked at it at all?
No, I don't think I looked at it, okay. So I unfortunately cannot comment on it.
Thank you, Katerina. In my research, I specifically focus on nebis in idem in general, so it's mostly about interpretation of the Rome Statute. But as to in absentia trial, I think how it will affect, you have to look at, again, admissibility framework of the court, and you can see that exceptions are about unwillingness and inability. And then the question is the state unwilling or unable? The fact that there is in absentia proceedings does not necessarily mean the state is unwilling, and also in absentia proceedings are not as such prohibited by international law and human rights law, so that does not also necessarily mean unfairness, although that is arguable whether the ICC, it's a question that is debated whether ICC can actually take over the case where there is unfairness towards the individual. Yeah, just a minute, but I think you maybe look at it in, for example, from the perspective of inability, as it was in, I think, in one of the Libya cases where the state wasn't able to actually have the accused in the proceedings, and the court, together with other aspects, that was considered as inability for the purposes of declaring case admissible.
Yeah, I just want to say a few words about trials in absentia. It was widely published in Ukrainian media that right now there will be proceedings against former President Yanukovych. I do understand the symbolic value of it. When I was doing my research, which was 1 year ago, I know that Ukraine sent around 400 extradition requests to Russia. All of them were left unanswered. And of course, it's important for Ukraine, in particular, as Ukraine is trying to seize the assets of Yanukovych, to make sure that you have some kind of verdicts. So on the one hand, I do understand why Ukrainian government want to introduce these changes to the criminal procedural code of Ukraine, because once we have some legally binding decisions of the courts, that would also legitimize the entire process that we have against the former government. But one has, of course, to be careful, because trials in absentia that have been tried in the absence of the accused, they're highly problematic. As here we have the problems with the fairness of the proceedings, and I think we also had this conversation before during this break, how these trials will be perceived by the Western partners. Will they perceived as vendetta against the former government? Because I presume if these trials are being run in Ukraine, that quite surely we're gonna get some successful convictions. And as well, what we could see, we know that Yanukovych and his inner circle members, they successfully challenged sanctions before the ICJ, and then the cases, as we as well already discussed, could be taken as well to the European Court of Human Rights, saying that the trials that were conducted by Ukrainian authorities that fall beyond the standards that are provided in the European Convention on the Human Rights. So this, there is no straightforward answer. So.
Thank you. More questions? So no question. Let me ask one question, maybe more for Irina and Valentina. It's what is the, in your opinion, is the main reason why the prosecutor doesn't open the investigation? And probably what is your view, when will it be open or not?
I'll be very short, if I can. Well, Ukrainian case is not the only case which is being considered by the C prosecutor. There are a lot of cases, and everybody's everybody's speculating. Okay, so what's happening with respect to the other cases? So here, of course, the prosecutor should prioritize which cases she has to take on. And the prosecutor has been criticized extensively for African bias. And although, as we know, these were the African states that have actually referred the case to the ICC, and the ICC prosecutor is herself an African, she nevertheless was always accused of the African bias. So for her, of course, picking up the case as Ukraine would be strategic, because she would show that the ICC court is moving away from the widely perceived African bias. But many commentators were saying that right now we have the case